Welcome to the webinar on global perspectives for business in resolving cross-border commercial disputes. Before we begin, just a couple of housekeeping matters. We have disabled the chat, so participants, if you have any questions at all, please submit it using the Q&A function. You can find the Q&A function at the bottom of your Zoom screen. There is a ribbon. If you hover on it, you can find Q&A, and that is where you will submit your questions. So we will submit your questions at the end, and the moderator will actually be assisting to help answer the questions with the panelists' help. And for those of you who are joining us and English is your second language and you prefer to listen to the presentation in Portuguese, there is a Portuguese channel available as well. So once again, if you have any questions during the panel session, please submit it using the Q&A function. And then your questions will be answered at the end of all of the presentation. So without further ado, I'm going to invite the moderator, Ms. Josephine Hadikusumo, to take over the session.
Hello, good evening, and welcome to this webinar, Mediation in Business, Global Perspectives for Business in Resolving Cross-Border Commercial Disputes. My name is Josephine Hadikusumo, and I'm very pleased to be your moderator for this evening, especially for a distinguished international panel such as the one we have tonight. It is my great pleasure to introduce our lineup of speakers. But before that, I would like to highlight that we're very, very fortunate tonight to be joined by participants from over 33 countries. So as you won't be able to see each other in this particular setup, however, please note that you have your fellow participants come from 6 continents of the world. And that is Asia, North America, South America, Africa, Australia, and Asia. I think we need to do more marketing in Antarctica. But we're very, very pleased to have such a well-rounded international audience, especially because of the relevance of our topic today. As you well know, these days, business enters an increasingly borderless situation. And where you have borderless commercial engagements, you tend to have disputes. So this evening's plan is for us to chat informally and to hear from the experts about all the different aspects in resolving such disputes, particularly through the methodology of mediation. And to begin with, I'd like to introduce our lineup of speakers. Our first speaker for this evening hails from Singapore, and he is Professor Joel Lee, the chairman of the Singapore International Mediation Institute. And Joel is a professor at the Faculty of Law at the National University of Singapore. And in addition to that, he has co-pioneered the teaching of negotiation and mediation in the Singapore universities. And he's played a significant role in furthering the development of mediation in Singapore, not just in education, but also in practice. Joel is a graduate of the Victoria University of Wellington and Harvard Law Schools. And he's a partner with the CMP Cambridge, USA, as well as a principal mediator with the Singapore Mediation Center. And a little bit of trivia about Joel. He is a wushu master, so you can say he is a dispute resolution professional in every aspect. He is an educator, a wonderful thought partner when it comes to alternative dispute resolution issues. And he's also what I'd like to call a grandmaster of puns, if you get to know him better. So he will be presenting a talk on standards, the bedrock of mediation practice. The second member of our panel is none other than Ms. Ana Maria Maia Gonçalves. Ana Maria has over 35 years of experience as a business leader in global organizations. She's also an educator, a mediator, and an executive coach. And she is the founder and president of the Institute for Certification and Training of all Portuguese-speaking mediators, and that's ICFML for short. Ana is a mediator on the Global Mediation Panel of the Office of the Ombudsman for the United Nations, and a fellow of the NCTDR. So Anna is a highly experienced mediator and educator herself, and we look forward to her invaluable insights. Anna will be presenting on the ICC Mediation Rules, and she'll be taking a comparative look at the global standards for mediation, why it's important, and what the differences might be. Our third speaker for this evening is none other than Professor Francis Lau Wai Hung. Now, Francis is the president of the Hong Kong Mediation Center, the Academy of International Dispute Resolution and Professional Negotiation, and another six mediation, arbitration, and advocates institutes, because clearly Francis has more than 24 hours in a day. He is a mediator and arbitrator of over 30 regions and countries. He's the head of the IDRRMI, and he is an invaluable resource if you have any kind of questions to do with the practice of mediation and advocacy and arbitration on Belt and Road and issues related to China. I know this is a big topic of interest to many people. Last but not least, we have Mr. Claude Amar. Now, Claude is based in Paris, but due to certain unforeseen circumstances, he's not able to make it for tonight's panel in person, but he is here in spirit and in video. So we have a pre-recorded message from Claude, and any one of us will be happy to answer any questions that you may have for Claude's topic, which is about the quality assurance and how Global Alliance for Mediation Standards translates to the bottom line. Now, I want to say that this talk is something that's very suitable for people who are interested or curious about mediation and its application in business, particularly in cross-border commercial disputes. But if you also happen to be a mediator, or you are involved in a center that does mediation, or you are in-house counsel, corporate counsel, or in any form a practitioner who is interested to explore mediation as a form of dispute resolution for your client or your business, then this is the seminar for you. I see that on the participants list, there have been many raised hands. I would like to remind everyone that we would love to answer all of your questions, and we will continue to answer them as the seminar progresses. However, most of these answers we may be able to do if you put in your question in the Q&A function. If you look at that panel at the bottom of your screen, it says Q&A. If you click on that, please feel free to put in your question over there, and myself or one of the panel members will be happy to answer it for everybody. So without further ado, I would like to introduce our first speaker for the evening, which is Professor Joel Lee. Joel, you have the stage. Thank you very much.
Firstly, Josephine, thank you very much for that overwhelmingly false introduction. But thank you, you're very, very kind. I don't know why she keeps believing that I like to tell jokes and I have puns. Those of you who know me know that I'm a very, very serious person and I hardly joke at all. Good morning, good afternoon, good evening to all our participants. Please pick the right one. In mediation, we believe in choice. Thank you for attending. I'm Joel, and I generally prefer to be called Joel. I trust you are all keeping safe and well during these very strange times that we are actually living in. So I'd like to say a few things. I suppose back in the day where we could actually go and attend concerts, you might actually be familiar with this term called the opening act or the warming up act. So I just want to state right from the beginning, I'm the warm up act. I'm here to warm you guys up for the main show that is to come. But what I also want to say, for those of you who like food, and most of you who are our friends in Singapore, you know that we love food. So consider me the appetizer. I know that itself might not be very appetizing, but it's okay. So I have really two purposes that I'm trying to achieve here today. The first is really to set the stage, making sure that we're all on the same page in relation to what we're going to be talking about. And that sets the stage for my friends who will come and speak with you next. The second thing I like to do is share some thoughts with you or about the notion of standards and quality assurance in mediation, and I'd like to sort of do that with you fairly briefly, and then I might take whatever questions you might have towards the end. Right. So that's how I'd like to proceed. So I suppose the starting point, and one of the things I need to say is, let me just turn that off for a moment, is that I know that we have a wide demographic in our audience today, right? We have mediators, I know that. We have some lawyers, I recognize some of the names, but we also have a number of business people who are no doubt interested in how mediation can help them resolve international disputes. So one of the things that I want to sort of get us all on the same page is what is this creature we call mediation, right? Now, there are a lot of ways of thinking about mediation, and one of the stories typically that we talk about in mediation is you might have heard this before, right? That there's these 4 blind men and this elephant, right? And so these 4 blind men have never seen this elephant, and one day they hear that this elephant's in town, and so they all said, okay, let's all go and figure out what this elephant is. And so the one blind guy held onto the trunk, and he said, the elephant's like a fire hose. The other guy held onto the leg of the elephant and says, no, the elephant's like a pillar. And the third one touched the side of the elephant and said, no, an elephant's like the wall of a house. And then the last guy grabbed hold of the tail and said, no, the elephant's like a rope. The elephant's like a rope. Right? And they're all correct, but they're all different perspectives on what mediation actually is. And from our perspective, and in Singapore, we joke about this because in the old days, about 20, 30 years ago, people used to think that when we taught mediation, we were talking about meditation. And I'm pretty sure that joke is first, this is a true story, but that joke is actually pretty common across jurisdictions. So just to get us on the same page, what is mediation? And this is also for some of the people in the audience who might be new to exploring what mediation is. So there are many definitions, but I'd like to offer you one definition where mediation is essentially a process whereby a third party neutral assists both parties to find a workable solution to their problem, right? And now, much ink has been spilled about definitions. Blood, I'm sure, has also been spilled between academics and all that about this. But bottom line is, I like to just highlight 2 features. The first feature is that the mediator does not make a decision and impose it on the parties. The mediator does not have a power to do that, right? And that is actually one of the key features of mediation. And the other feature is that the parties are the ones who come up with their bespoke solutions and agree to it. In other words, parties are empowered to enter into their agreement, right? So essentially, today I want to just be addressing really 2 aspects of what mediation is now that we've gotten sort of the definitional matter out of the way. The first is, this is one of the few times I'm sort of thinking about it this way because I've recently been reading about sort of sales and branding because the pandemic, and so I'm sort of thinking about mediation right now in terms of 2 aspects, right? Firstly, the need for that product, and secondly, the assurance of quality of that product, right? A dear friend of mine many years ago shared with me that he had to introduce mediation to a bunch of very hard-nosed business people in Denmark. And he shared with them a particular way of thinking about it. He shared with them a metaphor that comes from the field of medicine, a medical metaphor. And I'd like to sort of share that with you right now, if that's possible, just to give us a sense of what that is. So one of the questions that I have for you is that if you were ill and you had a choice, right? And first, let me point out that these 2 choices really are mainstream. So it's not like one is voodoo or witch doctory or anything like that, or alternative. Both are mainstream, right? And you have a choice. You have a choice between taking some medicine, which is more affordable, is non-invasive, has a 70% likelihood of recovery, right? 70%, and also allows for other options, In other words, if the medicine doesn't work, if you fall within that 30%, you can still go to something else, right? Okay, and you contrast that with the notion of surgery. it's relatively more expensive. Most of the time surgery is invasive. And there is a, well, okay, and these figures are not going to be 100% accurate. So the doctors in the room or people who know doctors are married to doctors, please forgive me. I'm not that kind of a doctor. But bottom line is you either get well or you don't. Right, so we'll put it at 100%, 0%, but of course, it's never, nothing's ever at 100%, nothing's ever at 0%. Actually, 0% maybe, right? But bottom line is that a lot of the time people focus on the 100% and don't actually focus on the possibility of a 0%, right? And surgery, of course, is a little bit like Armageddon and Armageddon. Armageddon just really does not allow for anything else or subsequent to it. Right. Now, of course, a metaphor is simply a metaphor, and it never accurately translates across every single thing. So if just point out, if we take it outside the metaphor, mediation resolves disputes far more quickly. Okay, mediation resolves disputes far more quickly, and so this isn't captured by the medical metaphor, but it is true. And mediation's time frame is generally measured in terms of months or even weeks, whereas in litigation or many other adversarial forms of dispute resolution is measured in years, right? So bottom line is why is there a need? Why is there a need? Well, bottom line is that, do you want something that's more affordable, non-invasive, gives you a 70% chance, and allows for other options first before trying something else, right? Now, there are a number of different objections that have been heard over the years in relation to this. And so I'd like to share with you some of these common objections. One of these objections is, I don't want to, right? You can hear parties say this. You can hear sometimes lawyers communicating this to the other lawyers, oh, my party doesn't want to, right? And actually, if you read between the lines, there's a little bit of saltiness in this, right? And folks, I apologize. I'm using a phrase which my younger students assure me means, like, you know, unwillingness, right? To when someone's unwilling, they say they are salty. I'm constantly being educated about these new terms that the young people use. So they're a little bit bitter, they're a little bit unwilling. I don't want to. There's a little bit of saltiness there. And you know what? Honestly, that's a choice here. You can choose not to. Could it be because you simply don't like the other person, because the other person has been annoying to you, there's no relationship, you feel that there can be no relationship? That's true. But one question that I invite you to think about is it really a sensible business decision, right? Mediation does not require you to like the other person. It's not conciliation. It doesn't really require you to fall in love with the other person. Basically, the question is it good for your business, right? Is resolving this fairly quickly and affordably good for your business? And if you think about it that way, perhaps we can, as the book Getting to Yes says, separate the people from the problem. Let's deal with the problem and people separately. Second objection sometimes we hear is, we've already tried law. So we already tried, and you know, no point now, we tried. We've tried, the lawyers have tried. Why does the mediator, you know, feel that he or she can help? Right. One of the metaphors that I like to use for me as a mediator is this: mediator is a catalyst, right? And folks, for those of you who don't know, a catalyst in chemical terms actually causes a reaction or encourages a reaction, but is itself unchanged, right? So the fact is that we already tried, and I will tell you that 100% of disputes going into mediation will generally fall into this situation about we've already tried. Despite that, 70% of all disputes referred to mediation, and this is an international statistic, settle, which means out of every 10 cases, parties don't believe they will settle, but 7 out of 10 generally do. Something happens, mediation happens, and mediator provides or acts as a catalyst for a number of different things. Finally, another common objection that we hear is that, you know what, it's not enforceable. It's not enforceable. Well, actually, there's a couple of points I'd like to make here, right? The first is there is actually a very high compliance rate in relation to settlement agreements. Basically, it means that when people have a part in owning the problem and creating and owning the solution, most of the time they comply. Right now, that is not to say that people don't sort of breached the contract, and therefore enforcement needs to happen. But then we look at it as that any deal, any agreement in a mediation is enforceable as a contract. Now, there are a number of different ways to think about it. It's a contract, and therefore it's enforceable. You can sue in court. I know that's an irony. We're going to sue on a contract that was settled in mediation, but sometimes life happens, right? But remember, there's a high compliance rate. Secondly, you can, in some jurisdictions, you can file your settlement agreement as a consent judgment in Singapore. Under certain circumstances, you can do that as well. And finally, and many of you will know of this right now, in 2019, the Singapore Convention on Mediation was signed. It came into force last year. And the notion of the Singapore Convention on Mediation was intended to make it easier to enforce international mediated settlement agreements across jurisdictions, across signatory countries. It's going to take us some time to get there, but the bottom is that in about 10 years, right, maybe less than that, we're going to find that there's going to be a simple mechanism, easy mechanism, a relatively simple way of enforcing international mediated settlement agreements across signatory countries and countries where the convention is enforced. Okay, so that's really all I want to say about need for the moment. The idea being that actually there is a need for the product, and one of the needs for the product is simply it's cheaper, it works. And it just makes sense to try it first. It just makes sense, right? I'd like to now turn to the other limb, which is the notion of assurance of quality. The assurance of quality is, of course, knowing that you need a product. So let's say you say, I need a mobile phone. You know it. You know you need it, right? Then the question is how, on the assumption that there are many suppliers of the same product, how do we pick the right supplier? In other words, how do we get value for money? I'd like to invite you to consider that there are a number of considerations. And these are not exhaustive, of course, but these are three things I just want to point out. Obviously, there is a price point involved. How much is this mediation going to cost me? Now, I said that it was relatively affordable. Doesn't mean it's free. Mediation should not be free. Honestly, I know we all like getting good free stuff, but how much do you really trust something that's just free, right? It's really a price point. How much are you willing to pay relative to the value of the matter that you're mediating, right? So it's always relative to that price. Okay, so that's one of the considerations. Second consideration is the brand. So when I say brand, I'm thinking of the service providers that are involved. So for example, the ICC is a service provider. It's a name, it's a brand. You know you can go to it, you know you get something reliable. Right, I will only speak to Singapore. SIMC, for example, is another such brand. Right, so these are things that service brand. Now, the third one is what we say affiliation. In other words, there may be service providers, some of whom are branded, who are affiliated with standards organizations, with organizations with their associated quality standards. So, for example, some of you may be familiar with the International Mediation Institute that is in The Hague. I currently am with the Singapore International Mediation Institute. That's a standard setting institute. So, and of course, I would like to think that we set quality standards for mediators. So bottom line is there are these three, I suppose, marks, three ways of actually trying to decide whether you have assurance of quality. Now, at one point, we can think about quality standards in terms of just your typical 4 questions: who, what, where, and how. Now, in a sense, I've already said a little bit about the who, and we've talked about the brand. We've talked about affiliation. I want to just very quickly talk about alliances. As you know, the speakers on this panel belong to organizations who are part of the Standards Alliance, and Claude, my friend, will speak a little bit later on this, and we're happy to answer questions on this. But sometimes we actually need to have groupings of like-minded people to come together and to essentially represent certain standards. So that's the who. In terms of the what, and a lot of people, when we talk about standards, they think about this, right? They think about what, and when they say what, they're usually thinking content. Right, content are essentially the rules and the guidelines that we're familiar with, what mediators should do, should not do. And it's sometimes phrased as an either or, okay, thou shalt not, okay, or thou should. And sometimes it's a continuum. Certain things are a mediator should endeavor to do these things as much as possible. So that's a kind of like a continuum. So for example, in SIMI, the organization I belong to, the code of conduct, three very key guidelines, rules about neutrality, confidentiality, and the ability of parties, the importance of parties deciding, right? And this is not sort of rocket science. A lot of people already sort of think this. A lot of organizations onto this, but we have consensus on this, right? Second thing that we can look at is criteria. In other words, how do we know somebody is a mediator, somebody is qualified as a mediator? Well, one of the things is actually checking out what their training and accreditation is, who have they been trained by, who would have they been accredited by. The other thing, which is a little bit dangerous, is your vintage. I call it vintage because I don't want to say age, because like wine, we get better with age. So, how many years have you been in the industry, right? Now, this may be good, this may be bad. It's not 100% great indicator, but it is at least one of the criteria we need to think about. Your experience, how many cases have you done? How many hours? Because all these count towards your leveling up, your experience points, as you will, for those of you who play computer games. And then finally, the notion of feedback, right? One of the key things is that we know whether a product is good or not because of feedback, of reviews. And so one of the things that SIMI does is that at the higher levels of at the mediators, we actually require parties to give feedback, right? And that feedback is encapsulated in a feedback digest. Now, the next one is currency. Currency, I don't mean money. What I mean is how current are they? In other words, are they active mediators? Were they accredited like 50 years ago and have not actually mediated in the last 30 years? Or are they current? Are they doing cases at present? And finally, and I want to highlight that I put a question mark there, the notion of a settlement rate. I don't suggest that people who settle are necessarily good mediators, or people who don't settle are not. Sometimes parties settle when they settle or not. Sometimes they don't settle. But sometimes settlement rate is just an indicia of whether how effective a mediator is. But I wouldn't go the other way where I say that if the mediator doesn't settle like a lot of the time, and they're necessarily not a good mediator, because the whole notion of settlement is that mediators should not pressure parties into settling. Okay, last slide, folks, the question of where is answered really by the context. Different jurisdictions, different cultures will require sort of different nuances, and I'm happy to speak about that more at a later point. And finally, the question of how do we assure quality? And there are just two things I want to point out very quickly. The first is initial verification. So for example, when you join SIMI for the very first time, we need to verify that you have your training and accreditation, you've done your hours. There is a process that needs to be followed where we verify the information you give us. And then there needs to be an ongoing verification, or we call sometimes auditing, ongoing auditing, that you continue to hold those credentials and continue to actually be in good standing, as it were. All right. So I've taken just a little bit more time than I anticipated. My apologies for that. But that takes me to the end of my very quick speech. For those of you who have sort of dazing over because I'm speaking too fast, I apologize. But that takes me to the end. Thank you for your attention, and I'll pass the time on to the next speaker. Thank you very much.
Hello, and thank you, Joel, for that good presentation. I wanted to add that there were quite a flurry of questions when Joel was speaking, and some of them were really, really good. So this is a quick reminder to everyone. Don't worry, we will get to your questions. And I see that some of my panelists have been typing answers, but for some of the really interesting questions, we will address them live when we have all the panel together during the Q&A session, because I think it's important to discuss these things. So with Joel's presentation, I hope that for those of you who are just getting to know mediation, have a clear idea of how it works in the whole gamut of dispute resolution options that you have, and why standards are really important. And we can discuss a little bit more about that on the fireside chat. But just to spike off from Joel's discussion on standards, I'd like to introduce Maia Gonçalves here, who will be zooming in on one set of standards in particular. And there are a few. but there's one set of standards that she would like to focus on in her talk, and this is the ICC rules on mediation. So without further ado, can I please invite Anna Maia to turn on her video and her mic. Thank you very much, Anna.
Thank you, Josephine, for your kind introduction at the beginning of the webinar. Welcome to all. I'm very happy to see that we have people from all over the world and that we have also Portuguese speaking friends that are here. I welcome all of you e bem-vindos a todos aqueles que estão aqui conosco hoje. I hope you are all safe in this period we are living. And my name is Ana Maria Maia Gonçalves, and you can call me Anna if you have questions for me on the Q&A. The agenda that I have for you today is we are going to start by explaining who is ICC, then a brief overview of what is mediation and the mediator role, mainly for I'm speaking for the business people that are here today with us. Why is interesting for the parties mediation, and why promoting standards international is important. And as Josephine just said, I'm going to cover the ICC mediation rules today. So who is ICC? The International Chamber of Commerce is located in Paris, and one of the main activities of ICC is dispute resolution. Dispute resolution is actually conducted in two different departments: the ICC International Court of Arbitration, which deals with all the arbitration proceedings, and the International Center for ADR, which deals with all dispute resolution that is not arbitration, so mainly is mediation. And the mission statement is: we make business work for everyone, every day, everywhere. So what is mediation, and why am I bringing this? Mediation is basically a dispute resolution proceeding by which the parties can come to a negotiation settlement. And Joel just gave another definition of mediation, but at the signature event of the Alliance for Global Standards that has been signed by all the panelists of this conference last April, Joel expressed that mediation represents one of the most sustainable methods of resolving business disputes, both domestically and cross-border, efficiently and effectively. And really, I agree with that sentence, and I want to bring it to you today. The main difference between mediation and other dispute resolution proceedings is there is not a neutral third party who will decide on behalf of the parties, who will say, under that applicable law, who is right or is wrong. That will not happen in mediation. It is a negotiation between these parties, these business parties, just conducted by them with the help of the mediator. And when these parties come up with an agreement which is acceptable for both of them, the end result of the mediation will be a settlement agreement. And this, what is the role of this mediation? You have several examples that Joel told you. And the mediation role and goal is in all of what to facilitate the negotiation between the parties. I used to say that if lawyers manage to settle dispute between themselves, they will not need the help of a mediator. So many cases coming to mediation have generally been negotiated before, but the parties did not reach settlement because they have escalated too much the conflict. So the mediator role is to help the parties de-escalate their conflict, to reestablish a constructive communication between the parties, and achieve a partial or a full settlement. And dear business people that are here tonight, or today, or in the morning, or in the evening, wherever you are in the world, why is mediation interesting for parties, for you? Mediation is an interesting way to solve business dispute because it satisfies the needs of your modern organizations. And why? First of all, because, as you know, as business partner in a dispute, like to keep control, like to have to a say to the outcome, and not just to be subject to someone else's decision. Mediation allows that. Also, in mediation, parties are not limited to claiming what they could get under the applicable law, but they can also protect their business interest, their reputational interest, their future business opportunities, or anything else which might be relevant. This is one of the main differences for mediation to other proceedings. And last but not least, mediation proceedings are confidential, less expensive than arbitration or litigation, and will typically resolve disputes far more swiftly than arbitration or litigation, while doing less harm to parties' existing relationship. So mediation is a service that really is relevant for the business world today. And so with the Singapore Convention on Mediation and the legal framework in place and the interests of business in mind, mediation use is growing. And with this growth comes responsibility of ensuring that there is a consistently high standards of mediation internationally to protect the users and to develop mediation as a professional practice. The ICC Mediation Rules are one type of standards that we are going to discover today. So I'm now starting to speak about the ICC Mediation Rules. The ICC Mediation Rules entered in force in January 2014 and are the outcome of a revision carried out by the ICC Commission on Arbitration and ADR in the previous ICC ADR rules. The ICC Commission on Arbitration is a body that is responsible to continuously improving the service that ICC offers in the field of dispute resolution. And this commission is like a think tank, a rule-making body that is composed of 1,000 members from more than 90 countries that comprise lawyers, in-house counsels, arbitration mediators, law professors, experts in various dispute resolution fields. So let's look at these rules, and starting about Article 2 and 3, commencement of proceedings. Parties may commence an ICC mediation irrespectively of whether their contract contains an ICC mediation clause or not. This is Article 2. Article 3 says of the rules deals with the commencement of the proceedings where the parties have no prior agreement to refer their dispute to mediation under the rules. Let's get a concrete example. Let's imagine parties have a dispute and the clause provides for a state court litigation, but part thinks it might make sense to mediate. One party may not dare to propose that directly to the other side, but might want ICC to propose it to the other side. And why can that happen? You know, because of cultural difference, because of wanting to ensure that everybody has the necessary information to take an informed decision, and also possible in order that the other parties seriously take into consideration the proposal and just don't immediately object it because it would come from the opposing party. So ICC can be a sort of communication conduit between both parties. Speaking now about flexibility throughout the rules. The rules are designed to be as flexible as mediation itself. Article 7, conduct of mediation. Parties are free to choose the settlement technique that is most useful for them, resolve that dispute, as well as the most appropriate type of neutral or multiple neutrals. That is possible also. The parties and the mediator are free to decide the technique and the approach to their mediation, so the course of the procedures. That's the Article 7, as long as they are compatible, of course, with the spirit of the rules. The only limitation set in the rules is that, and that's a main principle in mediation, the mediator shall be guided by the wishes of the parties and shall treat them with fairness and impartiality when establishing and conducting the mediation. So in real life, the first discussion between us as mediator and our parties is about the way how we are going to conduct the mediation, or the way how the parties want us to conduct the mediation. And then as mediator, we provide the parties with a written note with the summary of this meeting. And that is kind of what is going to happen in that mediation, and what is going to be the role of the mediator, how the mediator is going to conduct that session or those sessions of mediation. And under the rules, the parties may agree to suspend the mediation proceeding, and also the Article 9 of the rules state that proceedings conducted are confidential. Nonetheless, the fact that settlement proceedings are taking place is no longer confidential unless the parties or the applicable law have agreed otherwise. Speaking now about Article 5, selection of the mediator. Parties may either jointly nominate the mediator, or she or may be appointed by ICC. The center may also propose a list of mediators to the parties. The center seeks really to identify the candidates that have experience acting as mediators, ideally in international cross-border commercial disputes. The reason for such a requirement is that the disputes referred to ICC under the mediation rules are usually complex. And here the role of an organization like the ones present here today is crucial for giving the market this kind of professionals. Article 4, place and language of the mediation rules since 2014 allow to these issues to be decided by the center and not just by the mediator. And Article 10, parallel proceedings, the 2014 rules innovate in providing for the possibility to have parallel proceedings if this is the wish of the parties, so that the initiation of the mediation proceedings does not impede the initiation of other proceedings, like litigation or like arbitration. And Article 10.2 states that the parties may commence or continue any judicial, arbitral, or similar proceeding in respect of the disputes. Related to costs, the cost of the ICC mediation proceedings are composed by administrative expenses and mediators' fees and expenses. And the filing fee is $3,000 US as January 1st, 2018. And Article 2 of the appendix to the rules set the guidelines for the center to fix the amount of the administrative expenses. And the Article 3, the appendix of the same appendix, provides the rules to calculate the fees of the mediator. The average cost of an ICC mediation is around $20,000 US. Thus, when compared with arbitration mediation, remains far less expensive. Also, the cost of the proceeding is usually divided by the parties in equal shares, but these rules allow for one party to finance the entirety of the proceedings. In order to encourage the use of mediation, before or throughout the arbitration proceedings, 2 references have been added in the mediation and arbitration rules. When unsuccessful, an ICC mediation may continue to an ICC arbitration. In such case, the parties will benefit from cross-crediting, and 1/2 of the administration fees paid in the mediation case will be transferred to the arbitration case. If the parties refer their dispute to mediation after having filled a request for arbitration with the ICC, the amount of $5,000 pay as the filing fee in arbitration will be credited towards the administrative expenses of mediation. If the total administrative expenses paid with respect to the arbitration exceeds $7,500. I really believe that such a provision in the rules makes like having a mediation window, like we call it, less costly and perhaps more appealing to the parties already engaged in the arbitration. And we see more and more that happen. Parties that start an arbitration and that for one topic or another topic, they decide that those subjects are better solved in mediation, and they can move from one process to another easily. It's allowed on these rules. And so in conclusion, what we can say is that mediation is good for business, is good for you, Mr. Businessman and women that are here today, local and cross-border. Mediation is also good for parties from the same culture or from different cultures. And the development of mediation as a professional industry depends on the quality of standards of its practitioners, the mediators. And this quality of standards of its practitioners, as Joël stated in a very concrete way, are key for parties to feel safe when they come to a mediation. Parties in cross-border commercial disputes need to know how to identify a qualified professional mediator that follows international standards and that has its competencies and skills regularly checked. In ICFML, the institution that I'm the president of, you have regularly an obligation of continual professional development. We cannot just set an accreditation and just have it until we die. We need to continuously improve our skills, our abilities, our competence with more knowledge and more experience. The Alliance for Mediation Standards give these parties the assurance of harmonized standards with similar levels of quality. In that, we believe that increase the trust in the mediator and the trust in mediation process. And this is all I have to say to you tonight. And I hope that I was not too much out of time today.
Thank you, Anna, for that presentation on ICC. I noticed there were just so many questions that were being answered. I'd like to make a note that for some of these questions, even though they have been answered, because we find a lot of value in these questions, we will definitely revisit some of them when we have our panel discussion so that we can have a richer discussion with all the panel present. So please keep the questions coming. We really enjoy them. I think they contribute value to this particular discussion. So that was Anna talking about ICC mediation rules in general. Next is a topic that I think is of great interest to not only business practitioners who are interested in the China market or in projects related to the Belt and Road, as well as perhaps the practice of mediation or any form of alternative dispute resolution in Hong Kong or China. And we have no better person to bring us this particular topic than Professor Francis Lau, who is an eminent an eminent and distinguished professional in this particular area, and his topic will be mediation for cross-border disputes in the useful Belt and the Road initiative. So without further ado, can I please invite Professor Francis? Thank you.
Good day, good evening, and good morning for all our guests joining this webinar. I'm Francis, and I have a very good opportunity right now to share with you with some kind of international dispute resolution process, and that may be a very good way in resolving the dispute happen in the Belt and Road. So today we are going to share this topic and an effective international dispute resolution for the Belt and Road initiative as a mediation for the cross-border disputes. Well, actually, our speakers, including Anna and Professor Joe, have already talked about a lot of the standard and on using mediation. We'll have a particular focus on using mediation as an tools to resolve the dispute and what are the benefits, especially in the Belt and Road initiative. First of all, we have to go for international dispute resolution with mediation. We'll be very, very happy to present with the start idea of the Singapore Convention, which is based on the result of the mediation, have a settlement agreement that can enforce in other places. From the date of signing this Singapore Convention in 2019, we have already 46 countries joining. And right now we have already reached the number of 54, and over half the population of the world will be benefited by this new convention because they can use mediation as a way of resolving this dispute. So we look into the fact, basically, the purpose of Singapore Convention on mediation is trying to provide an effective and efficient single framework for cross-border enforcement. And we have a very clear that it will be particularly important to that the enforcement of the agreement will bring a lot of benefits to save the administration of justice by states. And we have a regulatory foundation to support the raise of mediation into many international dispute avenues. So we recognize that a value of mediation in international trade, people can use more and more using mediation as a very effective way to resolve. And definitely it is particularly good for working in different legal, social, and economic systems. We hope that this new convention will bring a lot to the world in international trade and also investment. When we look into the situation right now we have in Belt and Road initiative, we have over 60% of the population are in the whole system. So they will be looking for the trading and fair and provide facility for the places here to trade, to develop their economies. And we can have the figure in the next photo is talking about that the mediation, when we come up as an agreement or a convention in the area, say that there's in 2018 in the area, 2019 in the New York, the headquarters of the Institute, 120 representatives from 98 countries will join this convention and make reference to that. I'm sorry, it's keep on from. So from the day we go to Singapore to sign it on in 2019, so there was over 46 states joining. And from the figure, you say that the countries in blue colors actually are involved in the Belt and Road initiatives. And after the first day signing, we are now working on the another 7 have joining the Singapore Convention that actually they become this secretary country. So they will be have a total 55 of them. Sorry. Well, Brazil become the latest one joining, which is in this June to the 4th of 2021. And you can see from the figure here, she said is over 53 of the countries are signed in the world. They are Belt and Road countries, and that is talking about over 75 billion population in the world. That over 50% of the country have the population in this country have been signing the Singapore Convention. And from the first day, that is 2019, the 8th, the 7th of the August, about 20% are not ban-road countries. And right now is a little bit more because the joining of the Brazil become only 21% is not ban-road countries. You maybe have the question that Asia countries have been very highly involved in the drafting of the New York Mediation Convention, that is the formal main of the Singapore Convention. And also a convention, we can see it best meet the needs of the demand on ban-road countries. And the figure itself is explained because most of the joining are these places. We can know why is that, because in these places, they will looking for some kind of cross-border commercial disputes. We'll have a designable approach to work for the business. They were looking for some way they can use in a professional standard, very effective and efficient with certainty. That means the result from doing that kind of work provide a very certain result on the dispute settlement. And we have looking forward is something they can protect their business and also individuals in 4 different areas. They maintain the best equality among 2 different or multi-parties. They will have the opportunity to prevent risks coming again. And in the process, this method may maximize parties' interests in the process resolving. And they will be very, very much satisfying parties' needs. And for the recognition or enforcement, they will concern about the real world recognition on this approach and whether they can enforceable in different places. And otherwise, they will not be a very common or way to use a cross-border dispute resolution process. And also that will be beneficial to the economic development. And these are important, in particular, for the area in the ban-road initiative. You know that most of these places have not been joining other type of international convention on the day of drafting. But for this new convention that we draft in 2014 to 2018, most of the Asia places and also the country in the Belt and Road, they were joining to discuss. And unlike the previous convention in any type of dispute resolution, like the arbitration or the Hague Convention on judgment. So they will be having very good opportunity to look into how they can protect their very interests by using this way. And we can look into the basically, if we use mediation in resolve the dispute, it can really satisfy with what we have discussed in this page. They are efficient and effective, they are the economy, and they protect the interests. So what we have looked into the next step is what exactly mediation are and how it can really work for the business or individual in the dispute situation. Our speakers has been very clearly explained the mediation, what are they, how they can work. But let us look into another way of the purpose of mediation. First, mediation is a non-adversarial of dispute resolution. Unlike all kinds of dispute resolution, they are not basically doing the way in competing with each other. Aim at they are trying to do a non-adversarial approach. They can try to collaborate and with the other side. So in fact, mediation can be looked as a kind of facilitated negotiation. That means the party they concern is just the one who make decision on the whole process, and the one they join actually can go through a negotiation process with the facilitation by the mediator. Mediator in the process of mediation is not trying to make the decision, make the judgment. They are just trying to facilitate. And how they can actually go into a really constructive negotiation is the purpose of a mediator. They will facilitate parties to go into an atmosphere, a setting that allow them to join to have a constructive negotiation. That means they no need to take care about their emotion, their special concerns or other issues that may form the enmity or other kind of things. The way is trying to properly negotiate with the other parties and make clear what they have misunderstood. So mediator is a professional facilitates party in dispute to enter into a constructive negotiation with a will to settlement. So mediator has to cultivate and suitable environment and atmosphere for the party to communicate and clarify any misunderstandings. Mediator has to manage the expectation of parties, reframe their personal position into something they will be more concerned through the collaboration. They will be reframe their position into the focus on satisfying mutual needs and interests, not on their own self. A mediator helps parties to understand that they may maximize their interests through collaboration. Unlike other type of dispute resolution, people will concerned how to win the other side, how to take all or the most of the benefits through the process. But sorry, for mediation, they're trying to maximize the overall results together, because collaboration in most of the ways can bring up the synergy, and also they can have a better result or maximize their own interests as total. The decision makers are the parties, not the mediator or third party. Again, that's very important. So the decision maker will be very, very reliant on the party their understanding and their avoidance of future risks, and how to maximize their own interests. They will have very, very clear understanding on their interests, their needs, and also how to avoid the future risks they will have in the future if not going through a mediation to settle it. They will try to resolve the problem with others, not to fighting with the others. And so there are no need to solve right or wrong. We are not deciding which part is correct or which part is not correct. We are just go into looking on how to fix the problem, how to resolve it. And so we have to make very clear that parties we have to manage their expectation to not focus on their own position of winning the other side. We are just have to go on their interest, how to gain it, so that will be perfectly good for the business environment and setting, because we all look into the interests of either parties. So when we go further, when we use the application of mediation being the very effective and most efficient approach in solving their dispute, which can protect their interests, then we put it, if they can work out to go cross-border, that means they have to enforce in other places in way of they are not having a fully exercised by the parties. So when we look into mediation, we go first looking about the single convention, we have mentioned it, and we have to decide what exactly is an international mediation. They are professional design, really for dispute resolution, with very high standard of professionalism. So that's why we have to say that we have to maintain a very high standard as we align on the mediation standard. We have focused really on how to upgrade or how to make a cross-border standard on using this approach. So we can have a very reliable force or talent to help the disputant to resolve the dispute, even in case they have to exercise or they have to enforce outside the place of their signing their agreement. They will be proven, actually it's proven to be the most effective way of dispute resolution. And it's particularly important. Mediation is really something can take care, because they are basically a negotiation between parties under the facilitation of a mediator. So they will look into not only the legal aspect, not only look into the precedent case, but really look into the differences, including the cultural difference, the practice, and also because of their normal practice in their business or the professional, and also look not only relied on the judicial arrangement. If you are in different legal system, that's not a problem. But as long as you have something to show for the party, for their interest, their needs, it's across the board easy to be handled. So they have to specify, because of nature of this bill, they have a specialized arrangement for different kind of disputes, like what we have the trade, we have the investment in IP, or you have the investment in finance or other kind of work. Even you are going for a kind of we say that the maritime, or you are going for have a oil plant, all are of different concern or different needs, and that can be taken care by the mediation, while the other approach may not be really fit for that. And we have a very proficient way in how this kind of a cultural legal system and practice differs in different places. And so another way we are going for is, finally, what can we do is how international mediation can be enforced in worldwide. That means we are working right now, maybe we're doing the mediation in Hong Kong or in Singapore, but actually they will enforce in the USA or other places like UK. So in this area, in the previous setting, because we have, before we have the international mediation approach or mechanism, we do not able to enforce it, even they cannot finally been exercised by parties. So right now we have a more sophisticated design mechanism involved. First is the mediation convention, Singapore Mediation Convention, that will be having a very true or very detailed design on the rules of mediation and how it become workable, or they will be enforced by the court or the signed jurisdiction. Or we can use further is tooling is the aligned with the other international dispute resolution approach, including arbitration. So when we settle the dispute, we rely the arbitration system, that is the New York Convention. We can convert that into the arbitral award, and that can be exercised, rely on the New York Convention. Or we can actually do another thing is convert that into a notary. Well, so notary, international notary can also provide a facility for enforcement of the mediation. And finally, we can also rely on the conversion into court judgment. So there are different ways we can do the international mediation and ensure they can have a global enforcement. And for the Singapore Convention, definitely is a very new and powerful way of doing the international mediation enforcement purpose. Still, it is just have signed for 2 years, and we have just being enforceable, or we can put in effective last September in 2020. So we're still looking for and more places joining, and we can foresee that Singapore Convention will be the another very successful international dispute resolution convention after say 10 years time, that we're going to among the good as the New York Convention in the arbitration. We're looking forward to have more chance to work together in doing a more harmonic and more workable dispute resolution approach for the international trade. And with a very high standard, we are advocate by the Alliance of Mediation Standards. Having the time later on, we're looking forward to share a few more, and my presentation is up to here. Thank you very much.
Thank you very much, Francis, for the, I really love the slides. Actually, I just wanted to remind the participants that a recorded session of this particular presentation of this webinar will be on YouTube after this. So if you missed out on Francis's beautiful slides, please feel free to go ahead and grab hold of those. I would like to now take the opportunity to present to you our next speaker. Now, Claude Amar is not able to be with us today. I think there was a conflict, a last minute conflict, but he was kind enough to produce a video for our benefit. And any one of us panelists will be happy to answer any questions to do with his topic. So without further ado, I'd like to present our last speaker for today via video, Claude Amar. He's a registered architect, a hotel developer, a real estate asset manager, and a mediator. He was trained as an architect in Paris and has studied finance at INSEAD and negotiations at Harvard. And he was trained as a mediator by Gary Friedman at the Center for Mediation and Law in San Francisco. So to those who are asking, must I be a lawyer in order to be a mediator? Well, clearly from here, you can see that you do not have to be. And so without further ado, let me introduce Claude Amar's video. Thank you.
Hello. I'm sorry not to be able to be with you today. I want to talk to you about the Alliance for Mediation Standards. About 15 years ago, the University of Maastricht published a study which showed that mediators of poor quality were the biggest impediment to the development of mediation. It became apparent that the quality of the mediator's services was an essential element in the development of mediation. Many negative experiences were reported to us as having deterred justices, lawyers, and parties from resorting to mediation again. On the contrary, mediations by competent mediators had led these same types of people to use mediation each time a conflict was arising. Moreover, a bad mediator wastes the parties' time and money and may aggravate the dispute. It seemed to us that it is the moral responsibility of those who advocate mediation to ensure the chosen mediator's quality. This was the time where organizations dedicated to mediation quality assurance came to life, such as the NMI, the Netherlands Mediation Institute, the IMI, the International Mediation Institute, and the SIMI, the Singapore International Mediation Institute. It was, and still is today, essential to give to conflict resolution professionals, justices, consular judges, lawyers, legal directors, human resources, and CEOs the possibility to select mediators with full assurance as to the quality of their services. For these reasons, in May 2021, the following organizations have decided to join forces to implement mediation standards in order to provide dispute resolution users with a quality assurance on mediation services worldwide. These organizations are the SIMI, Singapore International Mediation Institute, the AMC, Asia Mediation Center, the ICFML, Instituto de Certificação e Formação de Mediadores Lusófonos, the IDRRMI, International Dispute Resolution and Risk Management Institute, and the IFCM, Institut Français de Certificação des Médiateurs. As to their objectives, the parties have decided to enter into this MOU in the belief that formal collaboration between organizations dedicated to the field of mediation standards will lead to mutual benefit between the organizations and, ultimately, results in a diverse range of quality services for the end user of mediation. Through this MOU, the parties commit to provide mutual support for each member in the following areas: upholding high standards in the training and assessment of mediation skills, upholding high standards in the provision of mediation services, encouraging intercultural exchanges relating to theory and application of mediation skills, gathering and disseminating best practices in mediation and mediation training, promoting the use of co-mediation via live or online means in partnership with mediators in different centers, promoting the use of mediation as a professional dispute resolution mechanism, and developing mediation into a recognized and viable profession. We have also arranged for cross-recognition arrangement. A fundamental basis for this MOU is to implement such cross-recognition arrangement between the parties. This arrangement will allow specific tiers of certified and/or accredited mediators from each party to apply directly for an equivalent tier of certification and/or accreditation with another party. The purpose of this MOU is to establish comparable standards between the parties, but not an automatic obligation to accept new members to their panel. Each party reserves the right to accept or decline applications made by individuals holding the equivalent certification and/or accreditation from other parties. As to new members, after the entry into force of this MOU, an organization that is not a party hereto may become a party to this MOU. New members may only be accepted with the prior written agreement of all the existing members. We are proud of what has been achieved thus far and are prepared to take such challenge to make it global. Thank you very much for your help and consideration.
Thank you. That was Claude, Amar, and that concludes our last speaker for the panel. Now we come to the very interesting and interactive part of our session. I would like to invite all the panelists to just turn on their videos, and then we're going to have a live discussion of some of the questions that you have presented for us, and also some of the questions that are even now coming in. And don't worry, even those that have been answered, if we feel that this is something that would benefit from a live discussion, we will certainly do so. I just wanted to bear in mind that to reflect the internationality of our body of participants and panels, a bit of trivia. I think the panelists here, we speak a total of 7 languages, and the participants of 33 countries and 6 continents. So we do expect a lot of questions that run the gamut from practice to the jurisdiction to even the Singapore Convention and the like. I'd like to start with a couple of questions that have already been submitted. There's one that's been upvoted very high, and it is, let me see. It is from Samuel Teo. And this question was for Professor Joel. Apart from the need to have a high quality of professional standards, what else, in your opinion, needs to happen to further the professionalization of mediation? Joel, please take this question, and if any one of the panelists are also happy to jump in after that, please do. The floor is yours.
Thanks, Josephine. I quickly jotted down sort of four quick points. And these are by no means comprehensive, so there will be other sort of points that members may think of. So I think the first one really is awareness of mediation as a service, and I think a lot of people still, as I said earlier, have misconceptions about mediation, don't know what it can do, don't know how it can serve. And we need to actually get that information out there. I mean, the purpose of this webinar is to do exactly that. One of the purposes of this webinar. The second thing that will contribute to professionalization is a system for developing mediators. I think one of the difficulties is that if there's only one practitioner or a very small handful of practitioners, it's well, you could call it a profession, but essentially it needs to have a far wider reach. And we need to have sensible ways of developing. In a sense, if we take a lesson from how lawyers developed back in the day, there weren't necessarily law schools and so on. So a lot of it was done by apprenticeship. A lot of it was actually done through sort of a work and learn sort of system. Later on, it became a little bit more systematized, and maybe that's the direction we need to be moving in. Third is we need to have more collaboration and consensus among mediation organizations across the world. And I think that's important simply because if everyone's doing their own thing and pulling in different directions, not guided by a larger vision of what the profession needs to look like, it then wastes a lot of time and energy, right? It's not that we're fighting. We may disagree about certain sorts of things, but the bottom line is we can all roughly head in the same direction for some kind of collaborative effort. That'd be nice. And as far as I'm concerned, if mediation is not a field that we can expect some kind of collaboration in, I don't know what field we can expect collaboration in. And finally, it's really connecting parties in need of mediation to the mediators. Right now, even if a party was interested in mediation, they wouldn't know necessarily where to go. I mean, they could Google it, They could find my site. They could find SIMI's site. They can find ICC site. They can find a lot of different sites, right? Some people feel, for example, that the dispute is worth so little that's really not much point doing anything about it, right? And actually, those lower value disputes can also be mediated by mediators who might actually be willing to take on those cases, because mediators actually also come from a place that they want to help. So, for example, the Singapore International Mediation Institute launched a couple of years ago now, something called SIMI. It's for those of you who are Singaporeans, you will understand that there's a joke, there's play on words on this. But SIMI really was a portal where users could actually submit their problems, and that the problems will actually be sent out to all participating mediators and mediation institutions. And then those mediators or institutions can actually submit proposals for dealing with that problem, right? And then it became a connection. So SIMI was not being a service provider; it was simply a portal connecting so with tongue in cheek, I'm saying it's a little bit like Tinder for mediators. You want that mediator, you swipe right. Okay. So I think from that perspective, for those of you who don't know what Tinder is, it's all right. So bottom line is those are the 4 points I think that we might need a little bit more to professionalize mediation. There's a lot more, but Samuel, I hope that helps. Thank you.
So I thought that was a very interesting question. I wasn't expecting you to bring up Tinder, but yeah, that's interesting. And then I think there's another really interesting question that Jeremy Lack. Hi, Jeremy. So nice of you to join us. I don't know whether you're now in Canada, North America, or in the UK, but I wanted to pick up on an interesting question that you had for the panelists. And the question you had earlier was, it is important in cross-border arbitration to have a seat or place of the arbitration. What are the panelists' views on whether or not the seat or place of the mediation should be specified for cross-border mediations, even if meetings may take place online or in any other physical location mutually agreed to by the parties? And I told you, Jeremy, that this was interesting, and I'd like to bring this up for the panelists. What do you think? Should we have a seat or a place for mediation, for cross-border mediation? Does it matter?
Okay,
Francis?
Yes, particularly for arbitration, we do have a very specified, talking about the seat and the place of arbitration. But for mediation, we are not looking on this because we're not a trial. It's not doing something like arbitration. We are trying to do the work of mediation in any place that's specified in accordance with our agreement. That's okay. So whether consider is not, you're trying to work out is the settlement agreement is work on the law or the requirement on the place of doing mediation is sufficient. And also that will be include, we will better include it as a mediation clause in all agreement that provide the opportunity in the future when party come to have a dispute, they will be easier agree to use the mediation as a mean to resolve it. And the mediator or the institution will have a very good support in working out the way how to make it enforceable or ensure their enforceability in the coming after work, after the settlement. So they will have the plan for working in the place of putting to the court in the exercise places, or they can actually have the way to convert into other way of dispute resolution site, say that they will convert into the arbitration award. They will arrange the whole facility, and no worry about the seat and the place difference. It's not an important concern in the mediation process.
Okay, that sounds like a good. Anybody want to add in, Anna?
I just put on the chat an article from Professor Naja Alachandar on that topic, and just to she just speak about the localization theory for the international arbitration and the delocalization theory for the mediation, and mainly she explains that the ability of the parties to self-regulate it by the laws and rules they have selected. this idea of the premium on parties' autonomy. And she speaks also about that this theory of delocalization for mediation rejects the idea of any supervision by a putative seat of the mediation. So I agree with her. That's my view. And also the fact that today we conduct mediation, as Jeremy said on his question, and as Francis pointed out, in different ways. We can start with an online, going to a face-to-face, then meeting on another place. And so it makes difficult to define, to identify a seat of the mediation. But last but not least, in my opinion, the last part of article that I'm referring to, Nadia just speak about parties can do what they want inside the mediation. They can renegotiate the contract. They can assume other responsibilities from the outcome of that dispute. So it's really the parties to decide on mediation, and that's what Jolie starts with this panel today. So for me, the notion of seat would not appear here as really important. But that's my point. And a question coming from Jeremy. Probably we could stay here for long discussing the topic.
Jeremy is an eminent mediator and a pillar in the mediation community. So definitely.
Exactly.
I would like to address a question from our friend Alexander Simoas over in Brazil. This was a very interesting question, which unfortunately Claude is not here, but I think as members of the Alliance, we can answer this. And the question is, how can we set the standards, meaning international standards, in such a diverse world with so many cultures and traditions and different jurisdictions? Will the standards be considered as soft law and things like that? And I just want to jump in real quick, and then I'll invite the panelists to come in. And this is what I think, Alexander, and to those of you who have the same question. Simply put, there is strength in numbers. There is strength in a harmonization and a coming together by centers when it comes to when we do the hard work of sitting together and saying, right, is this level the equivalent of this center's level? Can we harmonize this in such a way? And when we do the hard work, and when we come to that consensus, it provides a great harmonization. It provides an ease of cross-recognition. It provides security, most of all, to the end user, because the end user, in the bad old days, I think there might be people who are tempted to say, right, let me just put my name, write my name on a shingle, call myself a mediator and hang it on my doorpost, and then I'm a mediator. But this does not protect the end user. And by that, I mean members of the audience today who are business owners, who represent AmCham and all this. This does not protect the end user, because how do you know that this mediator has attained the relevant basic standard to be able to practice and properly facilitate such a process? This is not a soft law option. This requires great technical skills and experience. It requires a great talent. It requires a lot of hard work to do. So how do we then prevent anybody like mushrooms after the rain springing up and saying, right, so I'm a mediator? So how do we protect the end user? And so I believe the notion of having an alliance of sorts, where members of established mediation centers, for me, it's Asia Mediation Center, for Joe, Singapore International Mediation Institute, you've got ICFML, IDRRMI, IFCM, and other centers we hope as we get to evolve. When we do the hard work to sit together and work through all the differences, what are the things that we can accept? What are the things we consider similar? And then we lock shields and say, right, that is the minimum standard that we expect for the delivery of services. I think it provides a great service to the end user. It provides a great service to the people who are learning mediation, who are exploring mediation, and who want to be able to know, right, can I practice in Brazil? Can I be a mediator in Brazil if I have this particular thing? So I think strength in numbers is something that, that I feel very strongly about. And that's what, if Claude were here, he would probably say that's what the Alliance and the Global Standards for Mediation provides. That's the value we add to this scenario. Does anyone want to jump in on this particular?
Yes, for sure. And also, as I often say, it allows a person that speaks only his native language and that speaks very well that language and has all the skills as an excellent mediator to allow that person to be able to manage to be on international panels. Why? Because culture is different, because speaking that language in order to have a mediation, you can be with a co-mediator then from another culture, and that is the richness also of this alliance. You can be on a country, follow a set of standards that the institution of that country defined along with all these other institutions, and this for me is very important because we are all in the same place. We are all with the same objectives. It's not one that is more than another. It's not one institution that is setting the rules for the other. It's really the spirit of mediation. We are all together building these standards together, so all the users worldwide can trust mediation and can understand, yes, if all these organizations cross-border realize this together, all these mediators have a set of standards that protects, like Josephine said.
And it opens doors. It opens doors.
Exactly.
Right? Like if Joel wanted to be a co-mediator in a case in China with Français, he can do that through this. It opens doors for the mediators, and it opens doors for the end users who may want to have that feeling too. So I think we have time for like one more, we have a lot of great questions. We have a lot of great questions. We might need to have a part 2 of this seminar in the future and have even more time for questions. But I think in the interest of time, I would like to pick just one more question, and then the rest, please feel free. I believe our admin will put down our contact information in the chat, so that if you don't feel that your questions have been sufficiently answered, please reach out to any one of us or to reach out to Jessica, our admin, and we will be sure to try and organize another session where we can just have a discussion on this. If you just look at the chat later on, all of that information will be there. So our last question, let me see. For Francis, I think this is for Francis. Would you have an example of how standards was used to select an appropriate mediator for a dispute involved in a Belt and Road project? This is very Belt and Road specific, okay? How did this help? Oh, this is a multi-part question. How did this help agencies or parties to help identify the mediator, given that it is difficult to find someone who can bridge completely different cultures? You have the answer because you're in the alliance. So let's try it. And over to you, Francis, for this question.
Thank you, Jules. Well, actually, thank you, Elton. I see the question from you first. I answer to your first part of questions. Well, the standard has been mentioned by our colleagues very clearly. We do need someone have a very high standard in their skill application. They know the process and how to help their parties to really resolve their points, the difference with their knowledge and their skill set in using mediation. And the second part is how they connect this result in the other part of the world, say that in the Belgian countries, so that can be enforceable. This knowledge is a very basic one they have to go through. And because of this one, we form the alliance. And we do have the alliance right here to have organizations that particular assign their training, and also they have the course and assessment to make sure this mediator qualified to be an international mediator with a very high standard, and that will be easy. And that will be similarly for your second question as well. For the organization, we adopt this standard. So we approve the courses for training, and that pathway for them to go for the international standard. They qualify for the international mediator standard, they will get the license, or they can get the qualification as an international mediator. So they can work out very smoothly. But you have particularly corrected, because they are involving in two different places. They have completely different cultures. So we will encourage, another thing is we will assign or we welcome joint mediator. That means we have two mediators that will work together to know exactly their misunderstanding, their concern because of the cultural concern or practical issues. This will be why we say that we need to address on, especially for the cross-border one, we have to look into the cross-cultural issues. And with two mediators, that will be particularly good for the parties to understand, or they will present their misunderstanding or their cultural concerns very much. And that's what support we have, say that mediation is the one can effectively providing our party with the best way to understand the cultural difference, to resolve the cultural difference.
So I wanted to say, just because we have, so I hate leaving questions unanswered. So I'm going to say that for those of you who are here and you still have questions, please look out for another email perhaps coming from an admin. This time, we're not going to give you nice long presentations. Look out for a fireside chat session with all of the panelists here, and possibly Amar, Claude Amar when he's here as well. And what we would do in that fireside session is just to have questions and answers and discussions. And so if you are interested, those who have attended and registered for this session will have first priority. You can write to Jessica Lowe. Her email is in your chat. And then when we do have a particular session plan, we will be sure to send an email to all of you, because I don't like to leave questions unanswered. We're here to provide all of the guidance that we can muster humbly, you know, so if you are interested in a fireside chat, then we will put one together where all these questions will be answered. Okay. And I just want to thank all of you from 33 countries who have been patient enough to stay with us. Some of you at very inconvenient time zones for yourselves. We appreciate your participation. We love talking about mediation, and we love solving problems, particularly for our friends who are in the commercial sectors. There's a better way to resolve disputes, and we're here to help you with that. And so from all of us here on this panel, I want to wish you all a very safe week and a great evening. And thank you and goodbye from all of us. Thank you. Selamat malam.
Thank you.
Bye, everyone.
Bye, everyone.
Bye, everyone.
Thank you.